For our story, we're covering a case from the Commonwealth of Kentucky State Court, Court of Appeals, dealing with defamation as it relates to whether or not certain sports teams have engaged in prostitution services and the ability to seek defamation. So we're going to read this case and cover what it has to say. It should be pretty interesting, so let's get started. Appellants are or were University of Louisville students who assert a claim that the publication of a book called Breaking Cardinal Rules, Basketball and the Escort Queen resulted in a tortious diminution of the value of their education. They contend in the court erred in concluding that the defendants owed no duty to the students and erred holding the students were asserting claims not recognized by Kentucky courts. The cross-appellants argue that the court erred in dismissing their counterclaim for abusive process and malicious prosecution. For the reasons below, we find no error and affirm the orders on appeal. Appellants allege that appellee Katrina Powell claimed that she and her daughters engaged in or agreed to engage in sexual conduct with University of Louisville men's basketball players and recruits from 2010 to 2014 in exchange for a fee of $10,000 paid for by a University of Louisville employee. So apparently the allegation is that the university is buying their basketball players prostitutes. Okay. This claim was memorialized in a book called Breaking Cardinal Rules. The book was co-authored by Powell and Dick Cady and published by Indianapolis Business Journal Publishing. According to the record, the claims resulted in the University of Louisville self-imposing a post-season ban on the men's basketball team for the 2015-2016 season. So they killed their basketball program for a year. The litigation commenced in 2015 when a University of Louisville student named Kyle Hornback, great name for this case, right? Kyle Hornback, dealing with a prostitution complaint, outstanding, filed a complaint in Jefferson City Circuit Court against Powell and the book publishing, alleging the publisher was negligent per se for prostitution claims. The complaint also alleged claims against Powell for intentional interference with Hornback's contract and economic relationship with the university. The focus of the complaint was that Powell claims tortious diminution of the college education, also sought an order requiring the publishing to deposit any monies owed. Thereafter, the complaints were filed, which addressed more student complaints. In 2015, the book publisher filed motions to dismiss for failure to state a claim. The appellants then filed a third amended complaint adding claims against IBJ Corporation and Michael Maurer. Michael operates the book publishing and enterprises. In 2016, they filed an answer, counterclaim, and motion to dismiss. They moved to dismiss the claims. 2017, the Circuit Court entered an opinion or dismissing the complaints upon concluding they did not have standing because the claims were not recognized by Kentucky law. And this appeal followed. Appellants now argue that Jefferson Circuit Court erred when it held that appellees owe no duty to appellants. Students' claims are not recognized by law. In support of the contention, they present 5 theories of recovery, which they claim are recognized in Kentucky and upon which they may recover damages. The first is that they assert that they may be applied in unison to sustain a cause of action, 2 different chapters, one dealing with prostitution offenses and one dealing with a person violation statute may recover. They argue that they're within the class intended to be protected. Appellants cite by analogy case law in which plaintiffs were found to be members of a protected class for purpose of recovering damages sustained. Having closely examined the record and the law, we conclude the case law cited by appellants is distinguishable from the facts at bar. Appellants have not demonstrated that Powell or others were charged or convicted of any statutes violations, even if they had proof they're best remote and unconnected parties. We find persuasive the Circuit Court's reasoning that if the argument for recovery were allowed to stand, one could hardly foresee where the chain of liability would end, which is a fair point dealing with proximate cause. Appellant's second theory of recovery is based on a statute which states that every person contracting with any person or the representative of any person with respect to a movie or book or a similar expression of such person regarding crime shall pay over to the Tennessee Claim Commission any monies that would otherwise by term of contract be owed to the person. So basically this is a statute that says you cannot profit from your own crime. So if you're writing about things that you did that are illegal, you can't get money from those. Those, I think, originally were Son of Sam laws in New York, if memory serves correctly, dealing with the murder, where the person tried to profit from their own murder in terms of the book, and they're called Son of Sam laws. But this is, of course, broadened out since then to deal with any sort of criminal enterprise. So it's saying that if you're engaged in criminal conduct, you can't profit from it. Incidentally, this is the same principle, not the same statute, obviously, but same principle the U.S. government is currently using to go after Edward Snowden for his book. So he just come out with a book, autobiography dealing with his disclosure of secrets, and the U.S. government is suing for all the profits relating to that under the same theory. And it's the exact same rationale. You can't profit from your crimes. U.S. government's going to win there too. Just in case you want a spoiler, they are going to win that case. So we'll see how that goes. Appellants go on to argue they have causes of action stemming from the contractual relationship with the University of Louisville. They maintain they may prosecute a claim against appellants for tortious interference with prospective business advantage. Under Kentucky law, in order to recover, a plaintiff must plead the following: the existence of a valid contract, the defendant's knowledge thereof, intentional act of interference, improper motive, causation, and special damages. So this is essentially more or less the cause of action for tortious interference everywhere. The elements are slightly different, the burden of proof is slightly different, but this is basically your standard run-of-the-mill tortious interference claim. There is a contract, you interfered with it, you caused me damage. This is basically your rationale. Fine. Appellants contend they are prepared to offer evidence of diminution of value of the degrees resulting from the actions, as well as testimony of a psychologist who is expected to state that they suffered depression, anxiety, stress, and ridicule. I would think some ridicule might be warranted, yes. Appellants allege that while they're wearing University of Louisville logos and attire in public places, they're approached by strangers who made rude and hateful remarks because of the events in the book. The focus of the argument is that they tortiously interfered with the contractual relationship between the appellants and the university, and they failed to allow this cause of action to proceed. I don't see it, but let's see what the court says. There was a question that says, don't many rappers write autobiographies? Sure, many rappers write autobiographies. The question isn't, can you profit from an autobiography? The question is, can you profit from an autobiography dealing with criminal conduct? And the degree to which those books do or do not trigger criminal conduct, and to the degree to which they read on the statutes, is it's a question of how the law is written in a lot of places. As I was sort of trying to indicate before, these Son of Sam laws, which I believe is where this originated in New York, dealt with murder originally and have since been expanded, but they haven't been universally expanded or expanded all to the same degree. So it might not be the case that those rappers' violations are in violation of the relevant laws and the places where they are. So you need to know a lot more. And it might not necessarily be the case that they are telling true things that actually occurred. You know, if I write a book saying that I committed a murder and detailing murder, but I didn't actually commit the murder, then it's not illegal. You know, I've lied, but, you know, I'm telling you something about a murder I didn't actually do. You know, so I'm profiting from a crime that never actually happened. So some of these rappers may be fronting. They may be telling about things that never actually happened. So that's always a possibility. It should be considered too. Assuming arguendo that appellants have a valid business relationship with the university, they cannot demonstrate they committed an intentional act of interference with respect to that relationship. I would tend to agree with the court here. In order to sustain a claim with respect to business advantage, they must offer evidence of motive or intent to interfere. They cannot demonstrate the alleged sexual conduct with the University of Louisville basketball players and recruits was motivated by intent to interfere with that business relationship. I agree. That's a stretch too far. It's not intended to do that, right? The fourth theory of recovery is that appellee's actions constitute intentional infliction of emotional distress. As I was trying to indicate in a prior case, this is a somewhat difficult tort to prove. So let's see what happened here. The elements of this action are also known as the tort of outrage or intentional or reckless conduct that's so outrageous as to offend general accepted standards and causing severe emotional distress. It's a pretty high bar, though. The facts before us cannot sustain the claim for tort of intentional interference, infliction of emotional distress. While appellants contend that strangers ridicule them when they're wearing logos, they do not allege the degree of severe emotional distress necessary. That's true. It's a very high bar. The tort requires conduct intended to cause distress. Yes, it's intentional infliction. Intentional infliction. No allegation has been forwarded, nor could it be demonstrated that they intended to cause the distress. I agree. Fails as a matter of law? I agree. There's not enough there. The final argument consists of a single sentence in which they baldly assert that appellees were involved in a criminal conspiracy to injure them. With no reference to the record nor citation to any case law or statute, the argument falls well short of any overcoming the presumption that the ruling was correct. Yeah, so the court below made a finding, and you're not going to overcome that presumption from a mere bald-faced assertion. Great. The book publisher and Caddy asserted a counterclaim on abuse of process and malicious prosecution. In cross-appeal, they argued the court erred in dismissing the counterclaim for failure to state a claim. They maintained that they and the attorneys had an ulterior motive in bringing the action to restrain free speech, so basically an anti-SLAPP motion. Okay, fine. Further, the cross-appellants contend that the cross-appellees had and the counsel grossly overstated their claims and properly sought to join several liability. They maintain instead of accepting the truth of the allegations, the circuit court improperly concluded the statements were not prosecuting their actions with a purpose other than proper adjudication of the claim. They argue the circuit court had properly considered the fact in light most favorable, it would not have granted the motion. The essential elements of abusive process as a tort have developed have been to state an ulterior purpose, and second, a willful act in the use of process not proper in regular conduct of a proceeding. In considering the claims, the Jefferson Circuit Court acknowledged that the appellees were pursuing a common law claim not specifically recognized by the Commonwealth of Kentucky. In doing so, however, the court determined that they nevertheless had probable cause to assert their claim. That is to say, the court implicitly found the appellees did not have an ulterior purpose coupled with a willful act in improper use of the proceedings, nor did they act with the malice. So basically saying, look, this is a common law tort, and you have not made the allegations necessary as a matter of fact. Okay. Historically, a tort and malicious prosecution has not been favored. As such, the party claiming malicious prosecution must strictly comply. Yes, it has not been favored at law, which is one of the reasons that anti-SLAPP has been more of an issue of statutory than of judicial-made law. It is a disfavored remedy, and so the anti-SLAPP motions where they exist are designed specifically to overcome that presumption, as is the legislature's right to do, to create new law. So they're saying this is disfavored here because Kentucky doesn't have a statute on point. Fair enough. On question of whether the claim of abuse was properly dismissed, we find no error. The mere determination claim for relief was not supported by law does not demonstrate a willful act in the use of process nor proper in the regular conduct. As a tort and malicious prosecution could not prove the fourth element. Okay. We're not persuaded the Jefferson Circuit Court erred in dismissing the counterclaim before allowing additional time for discovery. They acknowledge in the ruling upon motion to dismiss, Circuit Court is not to weigh the evidence or findings of fact, but rather adjudicate the matter. As such, no additional discovery is warranted. Okay. So that is the case of Kyle Hornback versus IBJ Publishing. So long story short, the students cannot sue the publisher because the claims that they're making are not recognized at law. And we saw some analysis to that fact. And the book publisher's claims are either not recognized at law, and even if they were recognized at law, do not overcome the high bar. So basically, no one wins. Everyone goes home. The book publisher can continue to publish the book. The students have no claim for relief. Everyone pays their own costs. And the case is basically dismissed. So that is the end of this case. So the men's basketball team at University of Louisville has been alleged to engage in prostitution acts, and there is someone who said that they engaged in these acts for money, and there is no recovery possible under the facts as it exists in Kentucky. So I think this is a fair adjudication of the law as the court explained it to us, and so I see no problem with this, and so that is the end of this case.